Hello, my name is Nigel Blackaby. I'm a partner in the arbitration group at Freshfields Brookhouse Derringer in Washington, D.C. And I'm going to speak today about the question of the seat of the arbitration, the place of arbitration. Now let's imagine the representatives of a German pharmaceutical company and a US-based distributor have spent the day ironing out the terms of a distribution agreement. It's getting late. They've agreed on a New York governing law clause, and all that they have left to agree is the dispute resolution clause. Given their different origins, the parties decide that they want to settle disputes through international arbitration and not the courts. The attorney for the US distributor records that the ICDR is an internationally renowned institution with a model arbitration clause. She pulls it up online. It sets out the basic language, providing that any controversy or claim shall be submitted to arbitration administered by the ICDR under its international arbitration rules. Then adds that the parties should consider adding the place of arbitration shall be city, province or state, country. The parties look at each other. Where do they want to arbitrate? They want neutrality, so Germany and the US are out. They want easy flight connections, a place with nice restaurants. However, the choice of the place of arbitration is more important than the quality of the hotels and cuisine. This is because the law of the place of arbitration is known as the lex arbitri and will govern the arbitral process. But isn't that determined by the governing law clause, you ask? Well, no, it's not. The governing law clause determines the rights and obligations under the contract. The law governing the arbitral process, however, determines what rules apply to the arbitration and which courts supervise it. Why? Because arbitration, like many other activities, is governed by the law of the place where it's being carried out. In a way, it's like driving a car. Imagine a British man driving a German car in France. That man will need to obey French traffic rules, and if he gets in trouble, will be hauled before the French courts, because that's where he's driving his car. Now, what does the law of the place of arbitration determine? Well, first of all, it's often set out in a statute, such as the Federal Arbitration Act in the United States, and usually provides three broad categories of issues. First, the law of the place of arbitration may determine if you can have an arbitration at all. It will set out the requirements for a valid arbitration agreement. It will also set out the types of dispute that can be submitted to arbitration. Imagine that the parties have a dispute relating to intellectual property, but the law of the place of arbitration does not permit intellectual property rights to be arbitrated. You'll have a problem. Secondly, the law of the place of arbitration will determine what happens during the arbitration. Now, arbitration procedure is largely shaped by the parties' agreements and by the procedural rules that they choose, such as the ICDR's international arbitration rules. But any mandatory rules on the conduct of arbitration proceedings in the law of the place of arbitration will have to be applied. More importantly, the law of the place of arbitration will determine the level and type of assistance that the local courts can give to the arbitral process. This law will set out the extent and manner in which the courts can aid the arbitral process by, say, enforcing the arbitration agreement, appointing an arbitrator, or enforcing the tribunal's interim measures order. Third, and perhaps most importantly, the law of the place of arbitration will determine what happens after an award is rendered. So be careful to make sure what the rules of the arbitration say about this. Check. Can the merits of the award be appealed before the courts? Normally, no. Parties want finality, not a repetition of the judicial process. Check. On what grounds can the award be annulled or vacated by the local courts? The law of the place of arbitration will set out those grounds upon which a party can seek to have the courts annul or vacate. They're normally limited to procedural irregularities, the right to be heard, the absence of corruption, no exception or no exceeding of powers. Commercial parties want to have very limited grounds because they don't want an appeal on the merits. That's one of the reasons they went to arbitration in the first place. Another question that's important is, will the award be enforceable beyond the borders of the place of arbitration? Awards often need to be enforced against assets located in other jurisdictions. That's often because they're in neutral places. There are several international treaties that facilitate this, most notably the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, known as the New York Convention. This allows awards to be recognized and enforced in over 150 states. The New York Convention, however, only applies if the award is made, i.e. the place of arbitration, is in a country that has signed up to the convention. So, there are several key factors that should be taken into consideration in choosing the place of arbitration. Is it a country that is a party to the New York Convention? What does the arbitration law of that place say about the right to appeal, the grounds for vacation, the arbitral procedure? Is it based, for example, on the arbitral model law? Thirdly, what are the courts like? Do they have lots of experience with international arbitration? Do they tend to respect the arbitral process and defer to the arbitrators? Do they deal with arbitration matters expeditiously? Finally, there's a host of other factors, such as neutrality. You want a place with no connection to either party so that no one has a home field advantage if matters go to the courts. Convenience. Yes, believe it or not, it is important to work out what the airline connections are. What hearing facilities are available at the place? Are there dedicated facilities or will you be in a hotel? What's the language used by the local courts? Is it the same as the language of the arbitration? And with regard to cost, some cities are more expensive than others when it comes to legal fees, hearing facilities, accommodation, etc. To conclude, you may ask, is there any consensus about what the good places of arbitration are? Well, the following are generally considered safe bets with good arbitration laws that support but don't interfere with the process. My hometown of London, New York, Paris, Geneva, Hong Kong, Singapore. And with any of that choice, you can have the best of both worlds. Good hotels, great restaurants, and a safe arbitration. Thank you for listening.